Live from the drama-free true crime destination. No fluff, no filler, just the bites, breakdowns, and bold truth you need. This is the Midweek Bite.
And a good Wednesday evening, everybody. East Coast, West Coast, North Side, South Side, and everywhere in between to Bethea'S Byte Reloaded. I'm Ernest Bethea, the last outlaw, and this is the Midweek Bite. If I sound like I still have a cold, it's because I'm clearing up. Please bear with me as I go through this edition. This week's docket includes 3 new trials underway, a fight for a new trial, a huge verdict, and one case that brings me back to one of my earlier cases. So, without further delay, let's hit the ground running with that fight for the new trial. Shonda Vander Ark fights for new trial by declaring, "I didn't fake anything," quote, end quote. Now, before I break down how this all happened, let me take you straight to the article courtesy of our good friends at Court TV. Watch the left side of your screen. And there she is on the right-hand side of that screen. Convicted killer Shonda Vander Ark returns to the witness stand on this past Friday, where she continued to blame her dead son for his own death as she pushes for a new trial. Vander Ark was convicted of murder in the death of her son, 15-year-old Timothy Ferguson, who had special needs. Ferguson weighed only 69 pounds when he died. His death certificate listed dehydration among his causes of death. Evidence shown during trials showed that the child was handcuffed, forced to sleep in a closet, left in ice baths for hours at a time, and was starved. Following her conviction, Vander Ark appealed, claiming ineffective assistance of counsel. At a hearing in November on the motion, Vander Ark was unable to testify after claiming she felt like garbage and requested for an adjournment. Excuse me. 4 months later, the hearing continued in Judge Matthew Casel's Muskegon County courtroom. From the witness stand on Friday, Vander Ark continued to blame the victim's own behavior for his eventual death, saying that he chose to isolate himself and, quote, "he did not care to tell the truth hardly at all," end quote. She conceded that in May 2022, Ferguson had been 104 pounds, but could not say why he lost so much weight before his death 2 months later. Vander Ark bemoaned her conditions behind bars from the witness stand, saying that she was in a maximum security facility, isolated by myself in a room, quote unquote, for 17 and a half months before her trial. Prosecutors countered, was Timothy also locked in a room and isolated? What impact did locking him away, isolated, have on his own mental health? Vander Ark responded, "I have no idea how to answer that." Vander Ark's mental health became a focal point in her trial when she was unable to continue her testimony after appearing to vomit on the stand when she was shown a picture of her son. On Friday, prosecutors accused her of faking the incident. "Are you aware there was no vomit in that trash can once you left the courtroom? It's because you faked the vomit, correct?" Vander Ark responded, "I didn't fake anything. I dry heave all the time." The defendant claims she continues to suffer from dissociative episodes when she has panic attacks. But prosecutors attacked that claim by having her read from a medical report authored by a doctor who evaluated her. Quote, "Her purported memory loss was noticeably selective and only involved the actions that allegedly caused the victim's passing. Thus, Ms. Vander Ark cannot be considered a credible historian," end quote. Vander Ark read from the report. That's not true, she muttered under her breath after. Vander Ark told Casel on Friday that her court-appointed attorney at trial, Fred Johnson, rarely came to meet with her and failed to follow her instructions during the trial. Pressed by Casel, Vander Ark said that she was concerned about Johnson's performance before her trial, but admitted she never tried to alert the court. I didn't want to speak out of turn, she said. Talking about trial strategy, she said Johnson only focused on the allegations of child abuse, which formed the basis for the charge of felony murder that she faced. On the child abuse charge, it was intentionally and knowingly, Vander Ark explained. I didn't even realize second degree would be an option until the day of jury selection. Casel said he would take the matter under advisement and issue a written warning on the motion. She didn't fake anything, she says. Shonda Vander Ark, the Michigan mother convicted in the death of her 15-year-old son, returned to court arguing that she deserves a new trial. Vander Ark was found guilty of murder and child abuse for what prosecutors described as prolonged starvation and medical neglect. She told the judge she never fabricated symptoms or manipulated medical professionals, saying, I didn't fake anything. Her defense team claims that new evidence and procedural issues undermine the fairness of the original trial. They argue that medical findings were misinterpreted, that the state overstated her intent, and that the jury was not given a full picture of the child's complex health history. Prosecutors countered that the conviction was supported by overwhelming evidence, including testimony about severe malnutrition, unsafe living conditions, and a pattern of neglect that investigators say directly contributed to the teen's death. Of course, during the hearing, as I've read, Vander Ark maintained that she acted as a concerned mother, and the state mischaracterized her decisions as malicious rather than misguided. The judge took all arguments under advisement and will determine whether the case moves forward to a full evidentiary hearing or if the conviction will stand as is. Let's see. What are the chances that that it is possible that Shonda Vander Ark could go to a full evidentiary hearing and thus a new trial? Honey, what's the temperature outside right now? What's the temperature outside right now?
50 degrees.
So that means it's not cold enough to even think about snow, let alone make a snowman.
It feels like 45.
But still, it's not even cold enough to even think about snow, let alone make a snowman.
No.
Ladies and gentlemen, from Lady Outlaw herself, you just heard Shonda Van Ark's chances of getting a new trial, for at least from this point at Bethea'S Byte Reloaded. Next up, Jeffrey Spence is facing a retrial for allegedly killing her daughter's boyfriend. Now, what was that about? Let's see. Jeffrey Spence is heading back to court as prosecutors excuse me, prepare to retry him for the shooting death of his daughter's boyfriend. If this is a retrial, you know that must mean there was either a mistrial or a hung jury involved in this case. Ripley, Mississippi. Oh, excuse me, Ripley, Missouri. A Missouri man is standing trial for a second time on charges that he murdered his daughter's boyfriend during a robbery. Jeffrey Spence stood trial on murder charges in the death of Kirby Carpenter for the first time in September 2025. But the judge in that case declared a mistrial when the jury was deadlocked in a 6-6 split and could not reach a verdict. At the time of his death, Carpenter was dating Jeffrey Spence's daughter, Caitlin Spence, who previously pled guilty to accessory to murder in an agreement with prosecutors. Caitlin Spence testified at the first trial, telling the jury that her father confessed his involvement to her after she found the victim's body on his property. Caitlin Spence, even testified about the text with her family where her father suggested opening a business called Assassin Inc. The victim's body was found next to his driveway, approximately 30 feet from the carport. His truck was there, locked, with groceries inside. The keys to the vehicle and a large amount of cash were still in Carpenter's pocket when his body was found. Crime scene photos presented during Jeffrey Spence's first trial show that a curtain was draped over the victim's body and a toolbox was placed on top. Jeffrey Spence's defense Jeffrey Spence's defense maintains that he had no involvement in Carpenter's killing and that the defendant was at his home in Virginia on the day of the murder. At the first trial, Jeffrey Spence's attorney emphasized that Carpenter was known to sell drugs and regularly received threats from people he did business with, suggesting it in opening statements that Carpenter sold lab diamonds to a Tennessee jeweler and also sold meth. All right, here's what the breakdown I have from my own notes here. Jeffrey Spence is facing a retrial in the killing of his daughter's boyfriend, a case that has already seen one jury unable to reach a unanimous verdict, 6-6 split. Spence is accused of shooting the young man during a confrontation at his home, an encounter prosecutors describe as an unjustified act of violence fueled by anger and control. Investigators say the incident began when the victim arrived at the residence to see Spence's daughter. What happened next is sharply disputed. Prosecutors argue Spence confronted the boyfriend, escalated the situation, and ultimately shot him without legal justification. The defense, on the other hand, maintains Spence acted in self-defense, claiming the victim was aggressive and that Spence feared for his safety. The first trial ended in a hung jury, prompting the judge to declare a mistrial. Prosecutors quickly announced their intention to retry the case, saying the evidence supports the conviction and that the victim's family deserves a definitive outcome. As the retrial approaches, both sides are preparing to relitigate key issues: the physical evidence, the trajectory of the shooting, witness accounts, and Spence's state of mind. Jury selection is expected to be closely watched given the emotional weight and family dynamics at the center of this case. So, we have a guy dating a man's daughter, which in some cases no man is good enough for his daughter. So I can see that. I can see the part of the possibility of him not wanting this guy to date his daughter. I can see that. The rest is still blurry at best. What could Kirby Carpenter have done to push Jeffrey Spence's buttons like this? We'll just have to go for what we know right now and wait for all the evidence to be repiled in the retrial. Next up on the docket, a Massachusetts woman stands trial for allegedly poisoning her longtime boyfriend with antifreeze. This case is already days old, but it's still ongoing. This is the death by antifreeze trial, Massachusetts versus Judy Church. And we're already 5 days in. And we are in Salem, Massachusetts, where a woman is standing trial on charges she murdered her live-in boyfriend by poisoning him with antifreeze. 67-year-old Judy Church is charged with the murder of 55-year-old Leroy Fowler, who died on November 13, 2022, and has pleaded not guilty. On November 11, 2022, Church called 911 to report that Fowler must have ingested something and was pulling the bedroom apart with a bloody nose. When paramedics arrived, they found the victim with an altered mental status and in medical distress. He was taken to a hospital and died days later when he was removed from life support. When doctors told Fowler's family that they believed his kidney damage was the result of antifreeze poisoning, they immediately called the police. When police interviewed Church at her home, she refused to let detectives inside the door, choosing to speak to them outside. She denied that Fowler ate or drank anything before the incident. Church's adult son, Douglas Church, suggested that Fowler had suffered from carbon monoxide poisoning. Detectives spoke with Fowler's family, who said that the victim had been in a relationship with Church for years. But he had also had a second girlfriend. Fowler's stepson told officers that Fowler previously told him that he thought Church could be poisoning him because every time he leaves Judy's residence, he feels better. The stepson also told police that Church had offered him $10,000 to kidnap Fowler from his second girlfriend's house, tie him up, and bring him back to her. Fowler's family told investigators that he got a life insurance policy approximately 1 year before his death. Now, I'm gonna see if I can try to get you guys caught up on the testimony all the way up to today. Let's start from day one, which was the 18th. Let's see. Andrew Camelio delivered the opening statement for the prosecution, in which he said that the relationship between Judy Church and Leroy Fowler was toxic and horrible because Fowler had another girlfriend, which Church was not happy about. Church wrote in a notebook about Fowler saying she hated being alone, hated him for lying, and called Fowler's other girlfriend names. Church called the police on November 11th, 2022, which was Fowler's birthday, saying he was sick and could not stand or walk properly. Fowler died on November 13th. I'm all right, guys. Church told different people different stories about what happened. Police say Church previously threatened to poison Fowler if he ever cheats. Stanley Norconis delivered his opening statement for the defense, saying that Leroy Fowler left his family and started a relationship with Judy Church while he was a tenant in her home. Fowler began an affair with Barbara Randall, breaking Judy's heart. Described Judy as a bit of a fool but not a murderer. Testimony began with Monica Carnes, the dispatch coordinator for the Salisbury Police Department. She received a phone call regarding Fowler's medical issue, sent the call to the ambulance for protocols, and then the jury heard the 911 call from Judy Church. Adam Foss testified that he entered the building and found Leroy Fowler in medical distress, unable to communicate, rendered aid to Fowler, who was only making noises, and they showed Voss's body cam footage was shown to the jury. You still have other testimony similar to this from Fire Lieutenant Matthew Swemson, EMT Jonathan Lemke, Leroy Fowler's older sister Tammy Carbone, registered nurse Megan Worthouse, and Leroy Fowler III. Now that was day one. Day two, the stepson took the stand again to continue his testimony. That was followed by Sergeant Thomas Sullivan, who conducted digital forensics on Church's phone and found videos recorded by Church showing Fowler struggling on the floor. Detective Brian Verney testified for Salisbury Police Department. Angela Scheidegger, the ER physician's assistant, observed Fowler in the hospital. She was unable to administer a cerebral fluid test, and the lab came back with abnormal results. Massachusetts State Police Sergeant David Strong executed a search warrant at the home, found several empty bottles, including a de-icer, and 2 notebooks were found in the bedroom. Let's see. And that concluded day two's testimony. Day three saw Leroy Fowler's second girlfriend, Barbara Randall, testify, along with stepson Michael Hawkins, forensic scientist Jessica Brown, nephrologist Naomi Shin, brother-in-law William Eaton, and Salisbury PD Lieutenant Richard Delaria. Day four was mostly Sergeant Lewis Williams of the Massachusetts State Police. In his testimony, he spoke to Dr. Vaz, who was concerned about blood test results about possible antifreeze poisoning. Listened to the 911 call, interviewed Church and Leroy Fowler's family members, reads messages from the notes on Judy Church's iPhone, and a jury is shown her police interrogation video. And here we are today on day 5. Forensic toxicologist Daniel Anderson testified, along with forensic scientist Juliana Hopper, Quista Lundgren, and Leroy Fowler's cousin, John Haywood Jr. The trial is going to continue on tomorrow, and I'll be keeping a close eye on this particular case.
Tomorrow, you'll see mostly sunny weather, and can expect a high of 58 degrees Fahrenheit and a low of 31 degrees.
And that's the weather update from my Echo. Appreciate that. All right, here's the breakdown to this case. The case of Massachusetts versus Judy Church opens this week and bringing a rare and medically complex attempted murder prosecution into full view. Prosecutors allege that the 64-year-old Judy Church intentionally poisoned her longtime boyfriend with ethylene glycol, the toxic chemical found in antifreeze, causing a sudden and severe medical collapse that doctors quickly identified as consistent with antifreeze ingestion. According to the Commonwealth, the church administered the substance over time, exploiting its sweet taste and slow building symptoms. Investigators say the victim arrived at the hospital in critical condition, suffering from kidney failure and metabolic abnormalities that emergency physicians recognize as classic markers of ethylene glycol poisoning. Anyway, jeez, I thought I. Anyway, here's where I left off. The medical alert triggered a criminal investigation leading to Church's home and to what prosecutors described as incriminating statements and circumstantial evidence. The prosecution's theory centers on motive and opportunity. They argue Church was frustrated with the relationship, felt she was losing control, and acted deliberately. They plan to rely heavily on toxicology findings, expert testimony, and the timeline of the victim's decline. The defense counters, if I can catch that back, there we go. The defense counters that the medical crisis had no criminal cause, arguing that the Commonwealth is relying on inference rather than proof. They maintain that there is no direct evidence tying Church to administering antifreeze, and that the prosecution is overstating the certainty of the toxicology results. The trial is expected to hinge on forensic interpretation, medical testimony, and the credibility of the Commonwealth's reconstruction of events. The classic medical mystery becomes criminal case scenario now unfolding in front of a Massachusetts jury. I mean, I know it's day 5 of the trial. There's a lot of testimony that's recovered, and usually something like this could occur over one of two things: jealousy over the possibility of one, maybe cheating, or two, money. And right now, from the way the testimony looks right now, money is not that factor. Okay, guys, sorry about the delay. I was trying to look something up, think of something else, and I couldn't come up with anything. So I'm just gonna go ahead and move on to the next story in our docket, where a Georgia dentist is accused of attacking her ex-boyfriend behind a closed closet door during a violent confrontation. This is the dentist behind the door trial, Georgia versus Suzanne Miracle. And again, forgive me, guys. I'm trying to fight this cold and push through all this at all the same moment. All right. Today is day 6. That's behind the door trial. Here's the court TV of the case itself. A Georgia dentist faces a potential life sentence if she's convicted of killing her boyfriend, who was shot through a door. 62-year-old Suzanne Miracle faces a list of charges including malice murder, felony murder, aggravated assault, and criminal damage in the death of James David Barron, who was killed on March 7, 2025. Miracle and Barron began a serious relationship in 2024, and in October of that year purchased a home together on Lake Lanier. But prosecutors say that by March the relationship was having problems, specifically because Miracle had become aware that Barron was sending money to a woman from his past who lives in Moldova. Miracle's defense said it went beyond just sending money. Barron was allegedly bringing the woman and her daughter to the United States and was paying for a $3,500 a month apartment in New Jersey for them. In opening statements, prosecutor Jennifer Bagwell described Miracle as becoming unhinged and shooting the victim in a fit of rage after an argument. Investigators say when Barron retreated upstairs to the bedroom and locked the door, Miracle came after him and fired her Glock 9mm through the door. The bullet struck Barron, killing him. Bagwell said Miracle then got a hammer and used it to bang holes in the door until she could unlock it and get in. Once inside, Bagwell said in her opening statement, Miracle went into damage control mode. Rather than deliver any first aid to the victim, Miracle allegedly grabbed Barron's Beretta firearm and placed it by his hand, then fired 2 to 3 shots from the weapon. Bagwell also said that Miracle admitted to police that she flushed several rounds down the toilet before officers arrived. But Miracle's defense attorney, Brett Willis, told a very different story in his opening statement. He told the jury that while Miracle initially thought she was in a relationship with Prince Charming, the reality behind closed doors was very different. This was somebody who had opinions about what she wore, what she was to eat, what she was to do with the money from the sale of her dental practice. This was someone who put their hands on her over and over and over again. Miracle's defense said that on the evening of March 7th, Barron sexually assaulted the defendant before taking away her phone and the keys to the only functioning car before retreating to the bedroom. While her defense conceded that Miracle fired a shot through the door, they said she was trying to break the lock so she could get to her phone. Responding to allegations that Miracle tried to stage the scene with Barron's Beretta, Willis said that the 2 shots fired from that weapon were suicide attempts. And like I said, we are on day 6, and me trying to get through all the testimony like I want to, I would need a more detailed day to work this out for you. But you can always go through Court TV and YouTube to get yourself caught up on each day of a trial. In the meantime, the breakdown of this case went as exactly I read it out, just a shortened version. Allegations of a Savannah area. Wait, was that in Savannah, Georgia? Gainesville, Georgia. So that's probably somebody in the Savannah area. Assaulted her ex-boyfriend during a confrontation that unfolded behind a locked bathroom door. Prosecutors say Miracle lured a man into a vulnerable position, shut the door, then carried out a sudden forceful attack that left him injured and disoriented. Correction, killed the man. According to investigators, the incident began as a heated argument inside Miracle's home. The victim told the police he retreated to the bathroom to create distance, but prosecutors alleged Miracle followed him, forced her way inside, and assaulted him in a confined space where he had little room to defend himself. Anyway, the trial is expected to hinge on credibility, physical evidence from the bathroom, and the jury's interpretation of what occurred in those moments behind the door. Day 7, I believe, will kick off tomorrow. Next on the docket, it's the cop-on-cop shooting trial where a former Massachusetts police officer is standing trial for allegedly shooting her fellow police officer during a late night confrontation. Now, again, it said a late night confrontation, but I don't know if that'll be the case until I read this summary. This is day 3 of cop shooting. Massachusetts versus Kelsey Fitzsimmons, and we are in Lawrence, Massachusetts. A former North Andover police officer is standing trial on charges she tried to shoot a fellow officer in her home. 29-year-old Kelsey Fitzsimmons faces a single count of assault with a dangerous weapon and has pleaded not guilty. Prosecutors say the alleged victim was also a North Andover police officer, was in Fitzsimmons' home serving a restraining order when the incident occurred. Fitzsimmons, who had recently given birth, was served the restraining order from her ex-fiancé and allegedly began to pull her gun. While prosecutors have accused her of intending to shoot her fellow officer, Fitzsimmons' defense maintains that she was suffering from postpartum depression and intended to use a gun to shoot herself. Fitzsimmons was shot in the chest by the other officer and has since recovered from her injuries. Fitzsimmons spent more than 100 days in jail before their trial began. With days to go before a trial was scheduled to begin, Fitzsimmons waived her right to a jury trial, opting instead for a bench trial. That means Judge Jeffrey Karp will have the sole power to decide the case after hearing the evidence. She's having a bench trial, folks. So she is going to rely on the judge and the judge only to decide credibility, whether she's being truthful, and deciding her guilt or innocence in this trial. If there's two things I usually warn against, and I'm no legal expert, I would normally warn against: one, trying to represent yourself in court; two, taking your shot with a bench trial, leaving your fate in the hands of one person, the judge. This trial is expected to hinge on forensic interpretation, the credibility of the involved officers, and the judge's assessment of whether the shooting was deliberate or the result of a chaotic struggle among people who knew each other well. We will see how this plays out as day 4 takes place tomorrow. Henry Tenon is next on our docket. Henry Tenon is asking the court to suppress statements from his plea negotiations. We're in Jacksonville, Florida for this one. The man accused of being the trigger man in a murder for hire plot that killed Microsoft executive has asked for some of his statements to prosecutors be suppressed ahead of trial. Henry Tenon is second-degree murder, conspiracy to commit first-degree murder, accessory after the fact, and child abuse in the death of Jared Bridegan. Bridegan was shot and killed in 2022 while driving home with his youngest child after seeing a tire in the middle of the road and stopping to move it. Tenon initially confessed to his alleged role in the plot and told prosecutors that he had been hired by Bridegan's ex-wife, Shauna Gardner, and her current husband, Mario Fernandez Saldana, who were his landlords. But in 2025, Tenon announced at a hearing that he had given false testimony in sworn statements against the other defendants and wished to change his story. On February 17, 2026, Judge London Kite allowed Tenon to not guilty. When Tenon confessed, he had done so as part of a plea agreement he had reached with prosecutors. Under the terms of that deal, if he would have pled guilty to second-degree murder and been sentenced to 15 years to life after testifying against Gardner and Fernandez Saldana. Now Tenon's attorneys have filed a motion asking that all statements the defendant made to prosecutors as part of plea negotiations be suppressed and not introduced at his trial. Tenon's change of plea had made a big impact on the prosecution's case against Gardner and Fernandez Saldana. Shortly after Tenon's in-court statement that he had lied, the state filed paperwork withdrawing its intention to seek the death penalty against the couple. No trial date has been set for Tenon, but Gardner and Fernandez's trial is scheduled to begin in August. So what changed here? What happened? Well, he doesn't want those discussions regarding those plea negotiations. It should he doesn't want those statements used against him when it comes time for his trial. Prosecutors countered that the statements that at issue were not a part of confidential bargaining, but were made after Tenon had already agreed to cooperate, making them admissible. They argued that Tenon's words were voluntary, relevant, and directly tied to his role in the plot that led to Bridegan's ambush killing. The judge is determining whether the disputed statements fall under protected plea discussion rules or whether they can be used by the state moving forward. The ruling could shape how Tenon's cooperation is evaluated and how the prosecution presents its case against the remaining defendants. Next up, it's a throwback. It's a throwback for me personally because this is one I covered 3 years ago. And as I think about it, I start to get a little sicker than I already am. In fact, I want to see if I can pull this up on YouTube right now just to give you guys a bit of a throwback. Just give me just a minute. If I can pull it up, I can share it with you. I really gotta speed this thing up. Yep. Give me just a moment, and I'm going to take you guys back in time. And this is going to be fun. This is going to be a fun throwback. Oh, I see. All right. Let me clear this. And in a way I stand corrected, this was 2 years ago. Let me take you back.
And that was 2 years ago. One of from CBS News Miami and Gabriela Azola for that coverage then. That, like I said, that was 2 years ago. Today, we find out that that Jasmine Paez, unless she happens to mess up during her time out, she will not see any jail time. Let me repeat that for you. Jasmine Paez will not see any jail time for attempting to hire a hitman to take out her then 3-year-old son. Let me run it down for you. Florida woman pleaded guilty to trying to hire a hitman to kill her young child, but avoided jail out a plea agreement with prosecutors. 20-year-old Jasmine Paez pleaded guilty to felony charges of solicitation of first-degree murder, unlawful use of a communications device, and tampering with or fabricating physical evidence at a hearing on Monday. She had previously pleaded not guilty to the same charges after her arrest in July 2023. Paez was charged after reaching out to the website rentahitman.com, as you saw from my earlier reporting, with a service request for her son, who was then 3 years old. Assistant State Attorney Ayanna Duncan said Monday that Paez was a teen mother, that the child in question may have been the result of an incestuous relationship. She said that Paez's biological parents are both the maternal and paternal grandparents of the intended victim. Duncan described Paez as ill-equipped to care of her child when she met another young teen and began a relationship without disclosing that her child existed. When Paez revealed the truth, she was dumped and devastated, prosecutors said. That young man may have been the catalyst or impetus for even trying to carry out this plot, Duncan said, because essentially it was get rid of the child if you want me back. End quote. RentAHitman.com is a parody-based website in California. When its owners received the message from Paez, they passed it on to the police in Florida. Paez agreed to plead guilty after her attorney negotiated an agreement with the state that resulted in her avoiding jail time in favor of probation. When Judge Carlos Gomez appeared to question that decision, Duncan pointed to Paez's behavior while on pretrial release. During that time, the defendant graduated from high school and has nearly completed her associate degree in science. There's something to be said about that, and this is why we don't just throw an adjudication and on her record, Judge. Duncan noted that Paez's defense had asked for a penalty of just youthful offender sanctions, and the state said no, because that wasn't severe enough. So here's middle ground. You will get a withhold because maybe, just maybe, there might be light at the end of the tunnel for this defendant. Paez will be under strict community control for 2 years, followed by 12 years of reporting probation. Special conditions of her sentence include receiving behavioral therapy, undergoing a mental health assessment, and complying with any needed mental health treatment. Should she violate the terms of probation, she faces up to 40 years in state prison. Paez's parental rights were terminated for the minor child, and she is not allowed to have any contact with them. She now lives with her biological father, and the child lives with Paez's mother, who legally adopted him. Now, I am not going to go into detail as to how much I absolutely loathe plea deals. You just saw a good example of that just then. So I won't mention it. But to give this woman 14 years of probation, because she went on a website to hire a hitman to take out her 3-year-old son, and you give her 14 years of probation. I'm sorry, but did I just time travel 2 years from the day I reported that with backing reporting from CBS Miami 2 years ago, only to get to this point and find out no Ernest, what you heard, that wasn't real. You're in the Twilight Zone. I mean, who in their right mind would even consider hiring a hitman to take out their child? Say that again? I totally agree with you. Expletives and all. Ay, 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 ay. I've That's what I thought. I've seen it all. Just when I thought I've heard it all, I get something like that's why. That's the reason why I said that was a personal throwback to me, because I couldn't understand it. Then understand it today. I'm trying to put the best words together so I can go to the next story, and I am trying my. Oh, I think I found it, I think it just came to me. This is how messed up this is. Some stories force us to confront the darkest choices people make, and others show us just how far they'll go to hide them. That's all you need to remember. That's all you need to remember. Next up, this one I've got to file under justice served. I've got to, because this one was absolutely nuts to me until I figured the whole thing out common sense wise, and this guy got exactly what was coming to him. This YouTuber was found guilty of murdering his girlfriend, his pregnant girlfriend at that. And then on top of it, he tried to use a live stream of Grand Theft Auto as his alibi. Natalie McNally, as you see on the left hand side of your screen, was 15 weeks pregnant when she was killed by her boyfriend on the right, Stephen McCullough. McCullough staged a fake gaming live stream as an alibi on the night of Natalie McNally's murder. He was initially released and even consoled by McNally's family before investigators uncovered his pre-recorded ruse. He's facing a life sentence after being found guilty of murdering McNally, who was pregnant at the time. Let's get this. Let's look at this. An Irish YouTuber with tens of thousands of followers has been found guilty of murdering his pregnant girlfriend after setting up a false live stream that he used as his alibi. The victim, 32-year-old Natalie McNally, was fatally stabbed in her home in Lurgan, Northern Ireland on December 18th, 2022, per The Guardian. Stephen McCullough, the boyfriend at the time of her death, has been found guilty of the murder, according to the BBC on Monday, March 23rd. The investigation revealed McCullough set up a fake live stream to play on the night McNally was killed, according to the BBC. The 6-hour game of Grand Theft Auto Vice City and Robot Wars began streaming on December 18th, 2022, and became his alibi until investigators determined it was a pre-recorded ruse. While the game was streaming with McNally tuned in to watch, McCullough traveled to her home and killed her. She suffered stab wounds to the neck and strangulation and heavy blows to the head, according to the outlet. McCullough was initially arrested and later released after he provided the live streaming alibi. He was also consoled by McNally's family, who allowed him alone time with her coffin. The offense has a life sentence, the judge told McCullough after his conviction, but it wasn't immediately clear if he has been sentenced. Now, first of all, my condolences to the McNally family for the loss of their daughter, sister, and friend to Stephen McCullough. You got exactly what you deserved. And if you have been sentenced to life in prison, then good for you. You got exactly what you deserved. That's justice, ladies and gentlemen. And that's what we look for here at Bethea'S Byte Reloaded. Justice served. Now, before I go to our final story this evening, if you or someone you know are experiencing domestic violence, male or female, you do not have to suffer as a victim anymore. Help is just a phone call away, and you have lots of people who want to help, who are willing to help, who are able to help. You're asked to call the National Domestic Violence Hotline right now. That number is about to appear at the bottom of your screen. That number is 1-800-799-SAFE. 1-800-799-7233. Or you can get online and go to www.thehotline.org. All calls are toll free and confidential, and the hotline is available 24 hours a day, 7 days a week, in more than 170 languages. One call could change your life for the better. Call the National Domestic Violence Hotline right now. 1-800-799-7233. 1-800-799-SAFE. And now, I've saved what I would consider the best for last. This one also I can file in the Justice Served file. And you guys will get to see this, I hope. Apparently, Wednesdays are a good time to either start or end a trial. In today's case, a trial is, and we have a verdict in the fatal friendship murder trial, Utah versus Megan Sunwall. We're going to take you to the courtroom, and you're going to hear from the jury. All right, here we go.
Thank you. Please be seated. Ladies and gentlemen of the jury, welcome back. Who is the foreperson? Thank you. Has the jury reached a verdict? And is it a unanimous verdict? Yes. Thank you. Will you please hand it to the bailiff? The clerk will now read the verdict form.
State of Utah versus Megan Sunwell, count 1, aggravated murder. We, the jury, unanimously find the defendant, Megan Sunwell, is guilty of manslaughter. Count 2, obstruction of justice. We, the jury, unanimously find the defendant, Megan Sunwell, is guilty of obstruction of justice. We, the jury, unanimously agree the prosecution has proved the following act or acts beyond a reasonable doubt. Defendant altered, destroyed, sealed, or removed any item or thing, namely deleted text messages between the defendant and Casey Terry. We, the jurors impaneled in the above case, find the defendant, Megan Sunwell, guilty beyond a reasonable doubt of obstruction of justice as charged in count 2 of the information. Unanimously find beyond a reasonable doubt the defendant obstructed the investigation of the following criminal offense, manslaughter. Dated the 24th of March, 2026, signed the jury foreperson.
Does either counsel wish to poll the jury?
Not from the state.
No, Your Honor. Thank you.
Ladies and gentlemen of the jury, your service is now done. As I've stated before, we appreciate your attention and efforts in this matter. We know the time that this has taken out of your lives, and we appreciate your service. You are now, counsel, any objection to discharging this jury?
None, Your Honor.
Not from the state.
All right, you're now going to be excused. You are free to talk about this case with anybody you want. You're also free to not talk about this case if anybody has questions for you. But you are no longer under the admonition. Thank you for being here. Please be seated. Counsel, based upon the verdict, I'm going to refer this to the Utah County Office of Adult Probation and Parole for preparation of a pre-sentence report. We need to get a sentencing date to come back.
I might guess that we need a special setting.
Where are we looking, Brooke? That would work. What about the morning of May 4th? 8:30.
That would work for the state.
Sorry, looks like it would work. Thanks, Your Honor.
May 4th at 8:30, we will come back for sentencing. Ms. Sunwell, someone from Adult Probation and Parole will be meeting with you to prepare a pre-sentence report and recommendation. Counsel, anything else we need to cover before we adjourn?
Not from the state.
No, Your Honor.
All right, counsel, I want to thank you once again, all of you, for the professionalism that you've exhibited throughout this process. It's a tough process, and it's not easy, and it's about as serious as it gets. And I just want to thank you all for your help in this. All right, we'll be adjourned. Thank you all.
All right.
And there you have it. Megan Sunwall found guilty of manslaughter, but not murder, in the insulin overdose death of her friend Casey Lynn Terry. I've got a major breakdown for you. Here's everything that happened. After 2 days, roughly 10 hours of deliberations, a Utah County jury returned a split decision in Utah versus Megan Sunwall, convicting the Santa Quinn nurse of manslaughter and obstruction of justice while acquitting her of the top charge of aggravated murder. Prosecutors argued that Sunwall exercised control over her longtime friend, 38-year-old Casey Lynn Terry, ultimately administering a fatal dose of insulin on August 12, 2024. They pointed to a years-long pattern of messages between the two women, texts where Terry discussed suicide using insulin, evidence that Sunwall allegedly blocked rescue efforts as Terry's condition worsened, and the state's position that Terry was not suicidal, citing her online shopping and future medical plans shortly before her collapse. Investigators also highlighted that Terry had fabricated serious illnesses and a non-existent $1.5 million life insurance policy, which they say Sunwall believes she would benefit from, though no such policy was ever found. The defense's argument is Sunwall's attorney had maintained that Terry had a long history of threatening self-harm. The insulin overdose was a suicide or quasi-suicide attempt, not a homicide. The state relied on suspicious-looking things rather than proof, and if Sunwall intended murder, she would not have invited her parents to the home that day. So again, after roughly 10 hours of deliberation, the jury concluded that Sunwall was guilty of manslaughter, guilty of obstruction of justice, but not guilty of aggravated murder. The verdict reflects the jury's finding that Sunwall caused Terry's death, but not with the intent required for murder. Sunwall faces 1 to 15 years in prison on the manslaughter conviction alone. Sentencing is scheduled for May 4th. Wow. That case alone brought that old phrase, with friends like these, you don't need any enemies, to a whole new meaning. Let me go ahead and wrap this up before I leave you all. If there is one truth, ladies and gentlemen, if there is one truth that all these cases reminds us all of, is that accountability doesn't wait for perfect people. It waits for honest answers. And until every story gets one, we'll keep watching, we'll keep asking, and we'll keep. That's your midweek bite for this week. Facts, the updates, and the cases shaping the week so far. We stay drama-free, stay fact-driven, and we stay focused on what matters. Thank you all so much for joining me this week. I look forward to doing this again. I am Ernest Bethea, the last outlaw, and this is Bethea'S Byte. And it's reloaded. See you next time. Thank you so much for joining me here at the drama-free true crime destination. Please be sure to follow Bethea'S Byte Reloaded all over social media and support the channel through PayPal and Cash App. You can get your true crime news right here with no gimmicks, no drama, and no BS. This is Bethea'S Byte, and it's reloaded.